Okay, good morning, everyone. My name is Ben Slang, and I am a membership and business development coordinator at Digital. And I'm pleased to welcome you to our webinar, Data as a Commercial Asset, Privacy and IP Considerations from the Field. So before we get started, we respectfully acknowledge that in Canada, we live, work, and learn on the unceded traditional and ancestral lands of Indigenous peoples. As myself and much of the Digital team are based in Vancouver, BC, we are gathered on the traditional ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh people. And we encourage you to take a moment to acknowledge the traditional territory that you are joining us from. As a reminder, this webinar is being recorded and will be distributed to all registrants afterwards. If at any point during the discussion you have a question, please feel free to type it into the chat and we'll be sure to address them at the end of the Q&A portion. So with that, I'll pass it off to Jen, our Program and IP Manager.
Thank you very much, Ben. Bonjour, everyone, and welcome. It's wonderful to have attendees joining in from across the country for this month's webinar. Whether you're a new or a returning participant to Digital's IP series, we're thrilled that you are able to carve out some time to join us for this Thought Leadership Power Hour. Next slide, please. With the increasing rise of data as a commercial asset, particularly within the health context, there are important practical considerations in relation to intellectual property, as well as preserving confidentiality and achieving compliance with privacy and other regulatory requirements that must be considered before data is leveraged for commercialization purposes. Over these next 60 minutes, the discussion will center around the landscape surrounding data protection, some of the practical, technical, and legal considerations in obtaining and sharing data, and integrating systems and safeguards when using data in a commercial context. And as Ben mentioned, a Q&A portion to follow at the end. Next slide, please. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-industry challenges while creating technology products and services that can scale across industries and ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through numerous vehicles, and informational sessions with thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing our four thought leaders with us. Please join me in welcoming Patricia Thane, Craig Aitken, Lawrence McPhee, and Celia Wanderley. Patricia is co-founder and CEO of Private AI, a Series A Microsoft and BDC-backed startup, a multiple scholarship and fellowship recipient, Vector Institute alumna, and PhD candidate at the University of Toronto. Patricia's research and software development experience spans the McGill Language Development Lab, the University of Toronto's Computational Linguistics Lab and Department of Linguistics, and the Public Health Agency of Canada. And her R&D work is primarily focused on privacy-preserving NLP, applied cryptography, and re-identification risk. Craig has practiced commercial litigation in a national firm setting for many years, and his courtroom experience and personal interest in issues relating to unfair competition and the misappropriation of confidential business information and trade secrets has a proven record of winning trials, appeals, and hearings. He has successfully obtained extraordinary remedies in the context of injunctions, complex asset recovery, shareholder disputes, and insolvency. And fun fact, he first encountered working with classified information while working as a naval combat information operator in the Canadian Forces and sailed on several military vessels during this time. Lawrence is Director of Intellectual Property at Deep Genomics, a biotechnology company that focuses on AI-powered drug discovery and RNA therapeutics. Previously, partner at Berskin and Parr, practicing in the life sciences. He completed his PhD on the genetics of complex traits at the University of Oxford, law degree at the University of Toronto, and is a past member of the IP Institute of Canada's Canadian Intellectual Property Review Editorial Board, and has written on patents and patent strategy related to stem cells, natural health products, and computer-implemented inventions in the life sciences. And last but not least, Celia, Chief Technology Officer at Alta ML, one of North America's leaders in responsible applied AI for private and public sector organizations. Over 25 years of technology, business, and management consulting experience, where she spearheaded the leadership and delivery of large and complex technology transformation programs. Prior to joining Alta ML, Celia was with Deloitte in the Technology Strategy and Transformation Service and co-led Deloitte Canada's architecture practice. We are in for a treat and a wonderful discussion. And with that, Craig, I hand it over to you.
All right. Well, thank you very much, Jen. I'm very pleased to be here today, as I know the other panelists are as well. And thank you for everybody who's taken the time to attend today. I hope to have a very good session. Now, how a venture maintains privacy and confidential information, as well as trade secrets and rights over data sets as a commercial asset, is a critical element of intellectual property strategy these days. In addition to filing patents, more classical intellectual property, which I know Lawrence can tell us quite a bit about if you're interested, many business models, especially in the health and AI spheres, deal in data as a commercial asset. And this tends to interlink needs relating to how to maintain privacy and to safeguard proprietary information and data as part of one's both technology and business strategy. So I've been asked to give a quick sketch, and it is just a sketch about some of the key legal concepts and terms before getting into the meat of things. So I wanted to touch on a few key legal elements referenced in the title, namely one, trade secrets and confidential information, which is usually what I think of when I think of data as a commercial asset. It's how it happens within the law. And secondly, privacy legislation. All right, so for the first, the definition of a trade secret or confidential information is, first of all, not a statutory right that applies to, for example, that you can apply for, like a patent or trademark application, or that you may register, like copyright. It's more of an other or catch-all category. It's actually more of a flexible common law concept. It protects the right to restrict the use or disclosure of non-generally or publicly available information. The legal standard is that it must be relatively inaccessible. That's usually the one they use out of England, or to pivot to our neighbors to the south, not readily ascertainable. That's written into most of the American trade secret model legislation. So the wrongs often involve unlawfully using or accessing the holder's information source, i.e. it's not like a monopoly to an activity in a jurisdiction. That often becomes international once you begin looking at different treaty regimes, like a patent, copyright, or trademark infringement. Rather, the courts tend to talk in terms of either a breach of confidence or the misappropriation of a trade secret. Indeed, the courts often treat the nature of the legal wrong as more of a type of unfair competition when they get down to things, although it often manifests in employment law or contract breaches. And in fact, in practice, the legal wrongs on the trade secret or data asset front tend to be intertwined with contractual obligations, both employment agreements, particularly classically, NDAs and confidentiality agreements. Licensing terms, again, many businesses are enmeshed in networks relating to licensing and proprietary rights or data rights and that sort of thing, as well as non-compete provisions. Now, to turn to the second half of the title, I did want to touch, and again, just briefly sketch out privacy legislation and issues relating to regulatory compliance. I know Patricia is very knowledgeable in how to actually achieve these things, but I can give you some of the legal terms behind them. All right, so legal regimes relating to privacy tend to attach to personal information, often shorthanded to PI, or if you're doing it PII, if you're referring to the personal information identifiers. And some, but not all, business models involve seeking to commercialize or monetize data sets containing this type of personal information. Now, this is particularly prevalent in the health sector, although there are some other industries that do it if you're scraping data from the internet, but it tends to be an enduring concern because of the client records and consents that are often involved in health and medical research. The other regulatory compliance aspect is in Canada, there's networks of both federal and provincial privacy commissioners, which are regulatory bodies. Again, I don't have time to get into this, but we have a lovely overlapping federal regime. So you need a chart to piece together exactly what's going on. All right, a related issue relates to information custodians and the de-identification or anonymization of personal information. Again, Classically in Canada, this was often referred to as privacy officers, but I've been finding there's a pivot to using the European Union and the GDPR term of data custodian. Now, briefly, just to name some statutes, there's federally, there's PIPEDA, which is the Personal Information Protection and Electronic Documents Act. And I'm sitting here in Toronto, and so the answers might be a little bit different depending on where in the country you are. But in Ontario, there's FIPA, the Freedom of Information and Protection of Privacy Act. And many of the provinces also have health-specific regimes, which are similar but often bespoke or specific to the health sector. In Ontario, we have FIPA, or the Personal Health Information and Protection Act. In conversation, it's either PHIPA or FIPA, so it's hard to piece out. Now, one of the points that I'm personally interested in is that both privacy, regulatory compliance, as well as trying to commercialize data assets through more traditional methods such as trade secrecy or confidential personal information have a common, I would suggest, on-the-ground set of procedures relating to privacy and information security controls. And at least in Ontario, the Ontario Privacy Commissioner signed off on some of this in the specific context of commercializing data assets that derive from health sector and client information. So that's my little synopsis, and I was hoping to pivot to getting some of our speakers to answer some of the questions. And the first one I was going to ask is if they could tell us a little bit about how their companies, how they use data in a commercial context. And I was actually hoping to ask Celia to give us a little background about AltaML and how you come across data and how it relates to your business model.
Thanks, Craig, and welcome everyone to the conversation today. So AltaML is what we call ourselves an applied AI studio. We have teams in Edmonton, Calgary, Toronto, and Waterloo currently, and a little over 100 people. We operate with a two-sided business model. On one side, we build custom solutions to clients, primarily in the enterprise, and we have built hundreds of those solutions. On the other side, we spin off new ventures in specific verticals. So to date, we have spun off 5 different ventures, one in investment management, one in legal, one in executive recruitment, one in veterinary health, and another one in industrial automation. But when we talk about AltaML, we generally say the company's purpose is to elevate human potential through applied AI. And needless to say, our firm belief is that health applications and health data is where the largest opportunity to make a difference really is. So to your, maybe to part 2 of your question, Craig, of how we use data in a commercial context, essentially, we do not exist without data is part of the is part of how this goes, because when you think about other types of software, you can really build software based on rules. But we build software that is powered with with AI and machine learning at the core, and that cannot be done if you don't start with data. So essentially, like no data, no solution, no product. For the work that we do in our custom solutions, generally, clients will own the data, and will also want to own like the IP that's generated, like any data derivatives that exist there. But on the venture side, that's where the opportunity comes up to either co-own or co-own like the IP of the products created. So it becomes even more important to understand how are we going to source data, what changes are we going to make to that data and create derivatives, and have the right legal structures so that we can use data in a safe way, but also in a commercial context that where we're not breaking any rules.
Okay, Celia, just to repeat that back, one of my main takeaways was that the business model for AltaML, obviously you're coming in contact with very large data sets, but legally speaking, it's your clients who continue to have the rights to the data, and you're designing software around that. So I assume there's a licensing or contract thing where you're providing software development, and correct me if I'm wrong, software development and different services relating to that. But legally speaking, whoever is working with Alta ML continues to have the right to commercialize the data, to own the data, or however it's described. Is that correct, Celia, or am I missing something?
That would be correct. Yeah, on the custom application side, on the venture side, maybe a little bit some different alternatives there. So in some case, we have acquired the data set as the starting point, right, to make sure that things were simpler down the road. But I think the other nuance to Craig would be that there are some cases in which the client may not have a use for that. They want to protect a geography. So there would be non-compete, but where we could sell that in a different geography or something like that. So there are different ways, different arrangements on the legal side, depending on like each client situation.
Yeah, I do want to move on to Lawrence next, but one of the things that fascinated me about the law of this area is that it's unlike other areas where who quote unquote owns or has IP over trade secrets and confidential information is very much negotiated. It tends to be a function of underlying contracts and business relationships, which can be bespoke. And so that's distinct from, Lawrence can speak to this, but there's some related concepts in law, but you're not just doing one thing. It's often what does you and your client decide to set up for that particular relationship. All right, so I'd like to pivot to Lawrence and Deep Genomics. Lawrence, can you give us a little bit of
Thanks,
background?
Craig. So
yeah,
Deep Genomics was founded in 2015 by an AI researcher at University of Toronto named Brendan Frey, who was one of Jeff Hinton's grad students. So we've been in the AI game for a while, at least in relative terms. We now have about 100 employees across Canada and the US, offices in Toronto and Boston. And although as we started as an AI company, we're now more of a biotech company. So that's an unusual pivot. We have a wet lab, and I'd say around half of our researchers are sort of more on the biology side, and half are on the machine learning or sort of computational side for statistical inference. Our focus is on using machine learning techniques to develop novel compounds to treat genetic conditions, particularly in controlling gene expression. So you might have heard of mRNA, which has been sort of a hot topic since COVID. And so we focus a lot on sort of designing molecules and understanding mRNA biology to treat a host of conditions. We have internal research programs where we're trying to develop molecules and take them through IND-enabling studies and hopefully to the clinic. We also have a few large collaborations with big pharma partners. We are not a software as a service company. And so that's that makes our life a little bit easier, and that we don't have that same sort of interface with sort of public facing things. It's all quite controlled. But we certainly do need a lot of data. And that's key, as Celia said, to our existence, is getting these good data sets. We certainly have some expert modeling that comes into play and in the way we sort of use these things. But models are at the base of a lot of what we do. We generate a lot of data internally. And then luckily, certainly in the biomedical field, there's a lot of other options available to get data. But regardless, it's important that we sort of control access and think carefully about any contracts that we have with external partners, internally as well, as to how we proceed or how we use that data.
Yeah. So, I mean, that's fascinating. I mean, as you said, you were very much a data-driven enterprise, if I'm understanding correctly, Lawrence, but not in the same way as a software as a service. I know we spoke previously, you touched on how, like, my impression is not that Deep Genomics is selling what you would think of as data sets directly to other people. It's more you're selling patent and that type of thing. So you use data, but your commercial asset isn't the data itself in the same sense, or am I mistaking things?
Yeah, no, I mean, again, I think I describe us as a biotechnology company with a foundation in AI. So we started off with this remarkable AI ability, and most other biotech companies are now trying to import that technology or sort of learn how to use AI. We kind of grew up with AI. So that gives us a bit of, I think, an advantage in the space, and is certainly a different way of kind of proceeding it. But our end goal, of course, is to develop these molecules to compete with other biotech companies that are doing that as well.
Yeah, and so that would be, at the end of the day, that would be patented as much of the in-between processes might be a trade secret.
Yeah,
so,
patents are one aspect of it for sure. Yeah.
All right. So I'd like to go to Patricia and private AI. And I've always been fascinated by what Patricia does, because I can sit here and chat her about the legal requirements, but Patricia knows how to do it. My impression, and I may be wrong here, is that private AI, although distinct from Alta ML, is also somewhat of a software as a service business, but specifically in the field of making regulatory compliance happen. So Patricia, I was hoping you could talk a little bit about what private AI does, how it uses data in a commercial context. So.
Absolutely. So essentially our goal is to become the privacy layer for software. And very core to that is identifying what personal information you have in the first place, which actually is pretty tricky when it comes to data like text that's free, and also audio and images, documents, because you get really unexpected information coming through in very unexpected formats. So it's really key to use AI for that. Along with that, we also have a privacy layer for ChatGPT as well, and it basically uses the same core system. And to build the system, we have had to collect data in a variety of different languages. We support 49 different languages, and we have professional linguists, graduate study qualified linguists who manage the data sets. And where the sources for these data sets are, for example, we make sure that any data is open source and free for commercial use. We make sure that any data that we get from our customers, they have de-identified first, and we are allowed by contract to use it for training the models, and we then own the rights for the data. And we also use synthetic information that we annotate ourselves. And so what we do is make sure that we have clear range over the data that we collect and use to train our models. And we also make sure that all of the data that we use doesn't actually contain any personal information. And that way we don't have to worry about any data protection legislations.
So, I mean, one of the main things here, which is quite crucial in not just the health industry, but certainly the health industry, is you're basically how one achieves regulatory compliance, and then how one becomes I'm a data custodian, so we've done what's required. And so that allows these data assets to be used. Is that, yeah.
Exactly. And the really cool part is that we have the best system in the world for what we do. And we have not used a single drop of real personal information in training our models. So it's proof that you often do not need the PII in order to have good machine learning models.
Right, but it often, I think the underlying data sets you're coming in contact with will come with the PI in, the personal information in, and then you're using various sophisticated AI mechanisms, which I don't have a personal capacity to understand, to remove them.
Pattern matching, essentially, yes, that's right.
All right, okay, so excellent. I'd like to move on to the second question. And I was wondering, what are some of the particular considerations that your companies face related to obtaining data? If you could just touch on what are some of the technical and legal considerations that you bear in mind when sharing data with third parties as well. And here, Lawrence, I think deep genomics is quite different from Alta ML and private AI. I think I once
yeah, so we certainly generate a lot of data internally. The biomedical research field as a whole, I think, is maybe a bit ahead of the curve in terms of the public interest function and wanting to share data. So there's some great organizations like the UK Biobank that have huge data sets that are available to researchers, and we certainly benefit from those. There might be some personal information in those sets, so we do need to treat those quite carefully and make sure that we're up to the UK Data Protection Act or maybe the GDPR, depending on the timing and Brexit. But luckily, we're able to do that and carefully use those data sets internally. To great avail. So those are very helpful for us. We generally want to avoid any kind of encumbrances. And I'll echo Patricia's point about sort of having a gatekeeping function, is that where possible, you want to avoid personal information. It's just not, when you need to use it, okay, you put the necessary controls in place, but it's much easier not to have it, just sort of risk of encumbering your assets or problems or sort of down road that you might not even be aware of. And so because of that red flag, certainly, you might need to develop parallel systems if required, or just be very, very cautious as to how you use that data. But again, in the medical field, there is a pretty good history of sharing data, at least for research. For some of these new applications we're seeing for AI, for diagnostics and more patient-centered care, yeah, that gets definitely a bit trickier. You might need access to personal health information, and you need to be cautious when you do that. I mean, we also seek to publish data where possible too. despite the fact that, you know, we are working in a commercial context, something we think about and have to put controls into. You know, we want to sort of, spread the word about AI and machine learning and how to do these things effectively. But because of the IP considerations, you definitely need to be very careful about how you release your data and when or what form that takes. So
yeah, and to touch on what we spoke of earlier, Lawrence, I understand. I mean, if I didn't make this clear earlier, the regulatory compliance issues around privacy involve further disclosure or further use. And so if I'm hearing this properly, deep genomics tends to suck data in, but your actual commercial assets, your patents, or primarily don't involve personal information when you're actually
no, that's certainly they're a tool in our kind of toolbox that are used, but typically, again, we will avoid personal health information quite carefully, or we'll have access to these larger data sets where people like Patricia have have used software to sort of avoid these kinds of problems where possible. But I appreciate that's kind of industry specific to us and companies like us who are not necessarily dealing with patients directly at point of care. So
okay, so this is maybe a good way to segue to Patricia. And if Patricia, if you could talk a little bit about how private AI obtains data and what are some of the technical and legal considerations that you bear in mind when you are sharing data with third parties.
So how we obtain data, we always make sure that whatever data we obtain is available for commercial use when it is open source. What we do with our customers is they have to specifically hand over the data that they want us to have, and they de-identify it on their end, in part using our technology, and in part they do a manual verification, just to make extra sure. And then we do a third verification on our end as well, just to make sure, because any data that we want to hold, we want to make sure that it's properly anonymized. Anonymization is a very big word. You have to make sure that the individuals that are mentioned in the data set cannot, or the individuals whose data is in the data set cannot, that information can't be linked back to them. So you can't re-identify the individuals almost at all. There is generally a small threshold where there's an acceptable risk of re-identification. Not many legislations point out what that is. HIPAA points it to 0.04%. And when sharing data with third parties, we basically go through a very similar process, if ever. So when we share data with third parties, it tends to be either for example, making their own systems better, in which case the data also has to be anonymized or de-identified, or we just avoid sharing data altogether. There's generally very little reason to share data with third parties, unless it's, for example, something like a CRM, in which case, in those situations, those customer relationship management systems, they tend to obligatorily have personal information within them, in which case there's generally an agreement in place that mentions what the processing of that personal information is like, and you can generally have that information be deleted. Does that answer your question?
That does. But I was actually, it very much does, Patricia. But I was also going to mention you're underselling, I think, private AI a little bit. At least I know the Ontario Privacy Commission issued a big manual in 2016 about de-identification risk. And they were really quite concerned that people could use AI to re-identify people. That was the hot button topic within privacy law for a while. Would you say that, I don't know if it's private AI specific or just the industry's moved on in the last 7 years, wouldn't surprise me. But would you say that the risk of re-identification has gone down, or is it still present? Because again, certainly the privacy commissioners have written many cases and things saying that, you know, you can say that you would de-identify or anonymize something, but then AI can like pick up all the pieces again. So it's not really done, if that makes sense.
It really depends on the data set. And it really depends on what you've removed. If, for example, you have a call transcript and you remove the link to the original transcript, you remove the names and all the personal information of the individual, you remove the date in which the call took place, there's very little risk of re-identifying the individual. If you have a video feed of a corner and you remove all of the people in there, and you can see what the weather was like, or if all the people are blurred out, you could see how many people were at that crosswalk. But and you don't need the personal information for those tasks, and there is very, very little risk of re-identification, even with AI trying to go in there and make things out. Where AI could be useful is when it's not, well, for authorship identification, for example. However, you do still need to have samples of the person's writing in order to correlate the authorship from one piece to another. But also the actual systems that allow for things like authorship identification aren't necessarily very accurate, so you have to have a fairly small sample size. It is in theory possible that AI can help you identify somebody, but I think you have to look at it use case by use case and see what kind of information is actually removed and whether it was properly anonymized.
So there's not just one answer. So that's fascinating, but I do think I need to move on, as much as I'd like to keep chatting about that. But Celia, I was wondering what considerations AltaML faces when obtaining data. I know that you primarily are working with other companies to gather data which remains owned on their end. And I was wondering what specific concerns or points of interest arise from that.
Yeah, and I would very much repeat what Patricia just said, that for pretty much everything we have done to date, we did not have a necessity to have personally identifiable information. So we tend to get data that the client has done some work on it. I mean, part of our challenge is that most of our clients need help, not in doing it because we want them to do it, but in almost like teaching them how to do what are the steps, right? And when you think about it, like if you even take a step back and like not going to the technical ways of doing it, but the challenge starts much earlier. So I'll give you the example. In many cases, companies do not necessarily have a data governance framework that's very mature, and understanding what are the acceptable uses of data, who can approve something, and for what for what purpose is not always like well known. So in multiple of those cases, we have worked directly with information and privacy offices in those clients to make sure that some of those checks and balances are in place first, before we can then go into providing guidance on the technical side for our clients. It also seems to matter the stage in the life cycle. So if something is being done just as a proof of concept, there's a certain process to follow, whereas if it's moving to production, then there's a different a process to follow. So for example, going from a privacy impact evaluation to a full privacy impact assessment and things of that nature. On the technical side, okay, in addition to that guidance to maybe de-identification and making sure that not just for privacy reasons, but sometimes for bias reasons. So responsible AI is something that is very deep to our core at AltaML. And what we have noticed is that in some cases, there may be data attributes that may be deemed to be fairly safe and have nothing to do with personally identifiable information. However, they may lead to certain types of bias. So I'll give you example in some of benefits, social services type of sector, where a zip code may create certain challenges as you use that attribute. So I think the conversation has to happen both at the high level and on the governance framework and privacy frameworks. But then as you move into into the process to de-identify that data. And you had mentioned, like, I think, so I think I would see Patricia's company's technology quite complementary to services that we do, because otherwise we have to teach clients how to do that, right? Because we don't want to be doing it. And in most cases we do. I think the other element that I would just maybe add is where the work happens. More and more, in our case, the work happens on the client's environment, be it on-premise or be it on their cloud provisioned type of environment. So we'll get access to avoid that data gets transferred as much as possible. In case that there is going to be data transfer, then you're looking into all of the encryption types of safety measures to make sure that data is encrypted in transit, at rest, and even during its use.
All right, well, that's fascinating, partly because it then goes much into the next question that I have. And I just, again, to repeat one or two things back to you, Celia. One of my main takeaways was that although LTML does a great many things on the technical side of things, one thing that you find when you're dealing with your various clients is you actually need to provide training or information or directions relating to what I would call privacy and information security, like how this happens on their end. So companies haven't been doing this, and often startups don't have the resources to do it out of the gates, and LTML is often involved in training individuals and showing what privacy and security, information security compliance might look like. And my second main takeaway was that to the extent possible, you do prefer keeping the data sort of cordoned off on whoever's supposed to own it and provide the training on how to do that. But, to minimize the contact of third parties with the data sets. Is that correct, or?
That's bang on, yeah. Thanks, Craig.
All right. So again, I think that's actually answers a lot of the next question. So I might be pivoting or trying to get an expansion, but to move on, I was wondering, when a knowledge or data-driven enterprise is starting up, how do you integrate systems or safeguards with your business strategy? How might this look like in practice? And again, I think you've already answered this, Celia, as you're often directly involved in showing people how this might look like in practice, if I understood properly. Is that LTML's involved in some of the training and policy directives?
Yeah, but also I think, maybe just if I would say the recommendation to others, like a company, we are considered like a scale up, but when you think about the startup and some of what it can be pretty scary and overwhelming, like all that you have to do to be compliant. And so I know, like, more recently we have undergone SOC 2 certification process, for example, but that can be complex and expensive, right? And to work with certain type of clients, we have had the requirement of multiple certifications. So and when you go look at that, I think that's one study that we've conducted with a partner, like 80%, there was an 80% overlap in requirements of some of those certifications. So if we were to go and pursue all of them, like it'd be like just a big, heavy lifting. However, a lot of these frameworks provide a pretty good starting point for you to at least understand, okay, what do I need to do, right? So that it doesn't feel that overwhelming. So I'd say that there's good guidance that can come for companies starting to do, to work in the space, and especially, maybe technology, companies involved in technology space. I'd say that there is good guidance there, and there's a bit of, I think we face that with as I mentioned, we operate as a venture studio. So some of the companies we spin off are fairly small and still in that stage of trying to survive. And is my idea going to survive the market, right? So how do you, but again, if you're dealing with data, none of these requirements go away. So it's how do you have the good guidance and good compromise so that the safeguards are in place, but that that as a company, you can indeed, have the right processes and know what to do.
Yeah, so this is fascinating, and I'm sure we could have a full seminar on it, but I'd actually like to pivot to, I think it's been a while since we've heard from Lawrence, if you're comfortable, Lawrence.
Yeah, I'll jump in. Like, it is tough.
Deep Nugs, how did you set up? How did you integrate the safeguards that you have around?
Well, certainly
both,
for us, it's a bit different with 100 people and access to a lot of resources. We can call up lawyers and call up specialists and deal with it. But it's a small startup. You just can't spend all your time dealing with IP and regulatory compliance issues. So where do you focus, right? Like, you need to make sure you have a great product and then it has to fit with the market, and that's what's going to drive things forward. So, but I mean, it needs to be commensurate with your sector. So for sure, in the health space, you're going to have a lot more upfront regulatory concerns relative to some other things. If you're looking at large data mining, there too, be cautious. And of course, those frameworks, as we know, are still sort of evolving almost in real time. But things I'd point to early on, like cybersecurity is super important. And that's a place where I would certainly spend some time and effort. Having some written policies in place regarding data usage. I think Patricia and Celia both kind of referenced, like, who has access to what. Controlling access is really key, both from, I think, a data stewardship perspective and from an IP perspective. If you have important trade secrets, you don't want everyone to have access to those. Even if you're a small company, it's important to be able to show some degree of control over who gets access in case one of your employees leaves and maybe takes some of the secrets with them. You need to be able to document that, not exhaustively, but certainly have something you can point to. So those are three things I'd kind of say, have some written policies, focus on employment agreements as well. Make sure you have a good employment agreement as you grow in those first little stages with a few more people. Make sure you have your clear assignments and clear, data expectations, and and then the cybersecurity as well.
Yeah, that's excellent. I should mention that if you are facing unfair competition or an employee or business partner jumping over, then as a litigator, I love to see like written policies down, like Exhibit A, Exhibit B.
Yep,
Exhibit
you have something
C.
to point to.
Like,
It doesn't have to be
this is a trade
perfect, and
secret.
it never will be, but it's something. And
Yeah.
so figuring out that early threshold is, because it's a small company. I mean, I barely understand all this privacy and IP stuff, and I've been at it for a while. So I don't think, entrepreneurs start or note need to focus on perfection. But 3 or 4 things are that there certainly it is the fact that an ounce of prevention is worth a pound of cure.
I guess from my point is also, as a litigator, if an issue does happen, just saying, look, there were attempts to control. The person knew that they couldn't just like publish this in the paper willy-nilly or grab it and start their own enterprise. Like, it doesn't need to be perfect, but showing that it should have been understood to the people who come in contact with it, that this was a secret or it was private information that you're not allowed just to share willy-nilly. But one of the, actually, Lawrence, if you could expand on the point, I think Deep Genomics has worked beyond this, and we had a previous panel where we essentially told startups, think about it a little bit, but not too much. You need to build your business model. But at what point did Deep Genomics switch from being startup, I need some kind of income model or income stream, to we've gotten successful enough that at this point we're going to pivot back and improve, like develop cybersecurity guidelines and actually put some resources into this? So
well, I think having grown up as a computer company, and I joined a bit later on and it became more of a biotech company. That's my background, but really, and maybe Patricia or Celia can speak to this as well, but really careful, good sort of software engineering principles kind of apply across the board. And that goes to cybersecurity, data control, data management, that kind of fundamental stuff. And I know that's sort of, I think, what's important for startups to kind of get right. And I know even in a Health Canada AI document on medical devices, they pointed to sort of, focus on those fundamentals, because all these things are evolving. So, in Deep Genomics' case, because we started from an academic environment and things kind of took off quite quickly, luckily everyone was pretty computer savvy and had a sense of, okay, this is how I should have documentation to my software, or I should do these things. We should control access, 2-factor authentication, of course, like let's put all those things into place. And so people in the digital space, I think, are already kind of know these things. You want to remind the rest of your employees too, and just make sure you have that policy to be consistent. So that's my, again, sort of the fundamental advice is you can't control everything, but set some kind of goal target and hit that and consistently hit that if you can in terms of control.
All right. I was hoping to pivot back to Patricia, but due to time constraints and the fact that I see at least 2 questions populating, Patricia, I wouldn't mind touching on how do you integrate systems or safeguards with your business model strategy, but I was also hoping to have you speak to some international concerns in the European Union General Data Protection is it act or regulation? There we go. But just so that you know, I was going to hopefully touch on those two things sort of at once, Patricia. But would you mind telling us a little bit about how private AI integrates systems or safeguards into your business model? And I was hoping you could maybe describe how you show other people how to do that vis-a-vis internationally related to the GDPR. So.
Absolutely. So just to give some idea with regards to what multinational organizations do when complying with this patchwork of privacy legislations worldwide, a lot of the times they'll take the most stringent one, which is the GDPR often for them, and aim to comply with the GDPR, and then make slight modifications here and there for any other ones that might need doing so. For the GDPR, a core requirement is data minimization. So minimizing the amount of personal information that you collect to only what you absolutely need. Other things that you need to comply with are, for example, access to information requests and requests to be forgotten and data portability requests. And for that, you need to be able to keep track of all of the personal information you've collected, where they are in your systems, and also have consent for all of the uses of the personal information. Wherever possible, you also need to pseudonymize the data. So that means replacing the personal information with codes, if you will, that you can reverse into place with the original personal data. And if you anonymize the data, then it falls out of scope of the GDPR, which is an interesting thing that is now brought up in the upcoming privacy legislation, the CPPA in Canada. Under PIPEDA, anonymization was proposed as an alternative to data deletion. However, none of these legislations actually tell you exactly how to anonymize data properly. So the best practice is to bring in an expert to also just double check that the data is properly anonymized.
The best practice is also, at least right now, to do whatever the EU is saying, because they tend to be the most stringent. And if you want to truly be a global company, you know, you can forget sovereignty. You got to jump through the highest hoop if you don't want to gate your stuff, which I understand, limited to use in a certain geographic region, which I just understand is like indescribably painful. So, yeah. All right. I was actually we have a couple of questions, and I was hoping to give some time to that. So I was actually hoping to get Celia and Lawrence and Patricia to give maybe 1 or 2 minutes, no more than that, on some hot topics in AI. So Celia or Lawrence, I'm not sure who wants to go first, but you know, AI really has become a hot topic in boardrooms across Canada, and we have a lot of bench strength here in Canada on AI specifically. I was just wondering, what challenges or opportunities do you see in the future relating to that? Again, love to talk about this for a long time, but if you can just give a 1 minute little précis, I'd appreciate that. Do you want to go first, Lawrence, or?
Sure, I'm happy to comment on that. So something that I think AI is this amazing tool. There's all these efficiency gains that are possible. An area that I think globally will be of interest is sort of that human interface and how we get people to use these things well. And there'll be some iterative, doing that, but the best product and the products that are going to get taken up will have nice human features as well. So I think that's an interesting area where people who have an expertise both in maybe the architectures and as well appreciate that, hey, we need to sort of make these tools usable. I think that's going to be an interesting area in the future, getting that usability and that operability in place. Certainly we have a lot of AI expertise and we're looking at transferability. What other options, where can we kind of unleash our expertise in new areas? And that's tricky too, but is one that we're thinking about. And consistent with that is explainability. A lot of these AI models are somewhat black box. People need to want to know kind of how it works without taking away the magic of the black box and the fact that, we have all this great data. Well, there might be biases, there might be misinformation, there's all kinds of issues there. So I think explainability as well, and there are ways of doing that, and being able to convey that to the public is going to be interesting as well. So,
that's fascinating. I should mention, I currently see 2 questions in the Q&A, and in a couple minutes, I'll be turning to that. If anybody else has any questions for our panel, now is a good time to put them in. Again, I see 2 in the pipeline, but if anybody wants to jot down something they'd like our panelists to answer, that would be great as well. Celia, did you want to give a quick 1 or 2 minute rundown on hot topics you see in the AI sphere in both across Canada and generally.
Yeah, no, absolutely, Craig. So I think we're absolutely thrilled that it is becoming a hot topic, right? So there's a reason why we chose to pursue this area. We believe in the power that can have to do AI for good, and like you hear a lot, and I do believe it can be as transformative as the internet, but there's a lot to be figured out. So some of the things that we had already been talking about for so long, like the ones Lawrence mentioned in terms of like the black box risk, and like how do you use techniques that are a little bit more explainable as much as possible. So we only move on to techniques that are less explainable if it's really necessary, but for the most part, we'll adopt the whatever is a best fit to make those more explainable and help with adoption, as Lawrence had mentioned. So I would second that. A lot of what we have been up to in the last few months is really like the generative AI capability, and what should companies do about it, and what should government do about it, and how much regulation should. So we certainly believe that there should be governance and there should be some regulation, not to the point that it stifles innovation, but to the point that we all feel safe that some of the guiding principles are there and are in place. I think, having a daughter who's an artist, so that's something that comes up quite a bit even in my household of okay, what is the acceptable use of data to be training these models, and what for things that are now created by an AI, who's going to claim ownership of that content that is now original content. So I don't think we have, I think there's a lot to be discussed, and for us to figure out some of these questions that don't necessarily have great answers today. But the power of what can be done with this technology is incredible, and the power of what it can do for good is even more incredible. So I think we're committed to working really hard to make that happen.
I'm hearing two different things that are tearing different directions from both, I think, Lawrence and Celia. One is that, as you said, Celia, like the power of what can be done is incredible. And I've heard that a lot, as well as the AI regulatory context. I think partly to make it more acceptable, if you could at least say that you've met a standard by a public body that's thought about it, then it legitimizes it a bit. But the other thing I'm hearing is that commercially speaking, you also need to be able to explain what you're doing to real people. And I imagine that there's at least some tension between being able to explain what AI is doing, and for the highly trained experts who are doing the language learning and that sort of thing. Like, oh, I can do this, but if you can't explain it to anybody, people don't understand why there's utility there. So I'm hearing Lawrence and you, Celia.
Yeah,
We need to explain it. On the other hand, there's all these amazing things to do, and I'm willing to bet many of those are not easy to explain.
and there's a tendency to sort of, a phrase that I've heard is that AI is it's like the money laundering for bias. Oh, I have this black box now, but there still might be inherent biases in there. So I think we need to be cautious about that and how these systems work. And that is a tricky, issue that I think a lot of people who actually work in AI are very in tune with and are concerned about. So especially in Canada.
Yeah. So Patricia, did you want to give a 1 minute or so blurb on hot topics in AI, or challenges and opportunities that you see?
Sure. So I think, well, one thing I hear a lot is organizations trying to make use of their unstructured data, and it's finally making sense to do so because AI is finally at the point where it'll be useful for it in an accurate enough way. Unstructured data being text, audio, images, anything that's not in a structured database. And one thing I think is going to be a pretty big trend is understanding the cybersecurity impacts of these models that are trained on this 80 to 90% of the data that's collected. There's an understanding that what kind of access controls that data has. There's an understanding of what kind of regulations apply to those pieces of information. But when it comes to models, we're still trying to figure that out. And what we're seeing some chitter chatter about that I think is going to grow a little bit more is around what it means for those models when they're trained on particular types of data, including personal information.
All right, thanks. Now I'd like to turn to some of the other questions that our audience members have very kindly and thoughtfully put into the chat here. And the first one is from Beth Payne. So just to read it out. In the health space, there has been concern around exacerbating bias through application of AI. Lawrence touched on this. For example, related to race and sex. How is this impacted by removing all PHI from development data sets? That might be PII. Are there other approaches used by the speakers to address this? Flexible, do you want to take a run at this, Patricia or Lawrence, or who wants to field an answer?
Yeah, I mean, we would certainly include, where possible, sex as an input into most of our models, and knowing what inputs to put into your models, or whether unsupervised learning, you'd be maybe a bit more flexible. But yeah, one of the powers of AI is that everything can go in there. So you have to pick your data sets really carefully in terms of that you train with. In terms of how to deal with that, well, the more data, the better in a way. And sort of this depersonalizing the data set doesn't necessarily pull out some of that informative, that information. You can anonymize stuff while still maintaining a high information content within your data set. And Patricia might be able to speak to this more as well, but that's certainly a concern that we have, is that we want our training data set to be as exhaustive and full of information as possible. But that can still be anonymized. There's fine balance, but yeah, especially in genetics where, yeah, certain mutations might be indicative. But, and again, the anonymization is never going to be perfect. It has to be good.
Yeah, I mean, that's a great point, Lawrence. I'm gonna double down on that. I mean, for healthcare data, you often want that bias in the data because you want the models to be good for a particular sex, a particular race. You don't want it biased for, the overrepresented groups. And so keeping that sort of information can be very, very useful. So it's important
to targeted studies sometimes, is that? Sometimes you want all people of this group, the study specific to them. And so just because bias is sort of a generic bad term if you're reading the news media, but you're saying, Patricia, there's actually many studies are trying to get specific data sets, and that is also a form of bias. You may want them under certain circumstances.
Exactly.
Okay.
Yeah, exactly. And so it's really important to keep the use case in mind and the audience in mind for the final output of the machine learning model.
Okay. Right, that sounds like a good answer. Did you want to wade in, Celia, or should I move on to the next question?
Yeah, I think there's a good answer. I think the understanding of bias is more complex than it might seem, right? So that there's a lot of investigation of what the use case is, what problem you're trying to solve, and then go a bit deeper into what data sets may be a problem and which ones may not. So it's more complex than what might seem. Yeah.
All right. So I'd like to move on to the other question. This is from an anonymous attendee, but that question is, anonymization is one aspect of data usage, ... However, how do your respective organizations in a B2B2C model ensure that your client has obtained the free and informed consent from their clients to use their data for the new purpose? So I know that relates to that's a specific requirement set out of the GDPR quite a bit more assertively. Do you want to take a stab, Patricia, or who would like to wade into this?
If you anonymize the data, it doesn't fall under the scope of the GDPR, so you don't need to get consent for it. And that's sort of how you want things to be, because if you require that data to be under the scope of the GDPR, or if you require consent for the anonymization, that can end up meaning that you don't prioritize anonymization, and that would make the data less safe. And if it would fall under the scope of the GDPR or other data protection regulations, then you do still have to have some link to the original data, which also leads to more risk. So ideally, anonymize the data. Otherwise, it is still I think, very big question in the industry and in research, how you get proper informed consent.
Right, so anonymization can be, is it acting as a substitute when you're moving it around? Because again, if you have PII in it, then you're hitting into consent and privacy legislation issues. If you successfully anonymize the data, the point of doing that, as I understand it, is that you can then move those data sets around without violating privacy legislation. So, and we've also heard some things from yourself, Lawrence, and your deep genomics sucks that stuff.
No, I just
but you'd rather not see it in the first place.
Yeah, well, there's that, but I just be careful who you partner with too, right? That's just all, you don't want to necessarily get involved with anyone anywhere in the world, or depending on what you do. So just put take that cautious lens to taking data. Now that, again, it depends on the business model and how you're operating, but we're quite cautious as to what data we'll kind of bring in house and then use, and that of course gets tracked. And in our case, for these biomedical data sets, there's a long history of informed consent, at least in that space, which I think helps inform how those initial legal standards for initially bringing someone into a study, and the sort of the research community has already established some pretty good guidelines along that. Perhaps less so in terms of other kinds of personal information, which is now out there and kind of being scraped and used. So,
all right. And Celia, I understand that my impression, Celia, is that AltaML is often, i.e., your clients tend to be the ones who are owning the data, but you're often showing AltaML's clients how to put in processes that would be compliant in different ways with anonymization and that sort of thing. Do you have any comments about relating to this question about free and informed consent when you're dealing with the clients that AltaML is liaising with?
The only thing that I might add is that there is what legislation says and appetite for risk. So in sometimes, especially dealing with public sector clients, the appetite for risk is much lower than what even the legislation would allow them to do. So even if there isn't, maybe, okay, you check, you're good, but there's still not the appetite to go there because of a perceived risk, and what would happen if somebody, if the public were to perceive that that their data is being used and there's not specific consent for that use. So we go a little bit more into the acceptable uses of data and what a client would have provided. The first, what the client, the secondary uses and the first, like the approved uses of data, so which may be beyond even what legislation would require.
All right. Well, I've really enjoyed this talk. I know I've personally learned a lot, but I think I know, in fact, that we've come to the end of our allotted time. And as much as I think each of you, I could continue merrily chatting away for an hour or more, I would like to hand things back to Jen to conclude this session.
Thank you, Craig. And before we do, I just wanted to also give you the chance to, if there's any sort of final words that you'd like to share with everybody on the call.
Well, I actually spent, partly because I had young kids at the time, but 2 years delving into the concept of ownership in law, and specifically related to data sets. And I should mention that it's not the same type of controls that you have for statutory IP. Like, it tends to be talked about as a unit, but like we've been talking about how it's very bespoke what you're doing. Let's keep it over here, and I'm getting access to some of it, but who has the rights over the data is very much a thing that's negotiated between sets of parties. It is not an area-wide interest like you have with a patent, which you can register internationally. So I did want to mention that this has very much, one of the main subnotes of all of our speakers is that they're negotiating with other parties about what the rights to ownership will be and whether this includes PII or not. And so this is quite a bit different, I would suggest, and Lawrence would know more than I, but then I would suggest then that the types of rights you get for infringement cases for the classical trio of patents, copyright, and trademarks. And so I know that we talk about trademarks and commercialization of data sets, but it's a bit different in kind than the statutory stuff.
Thank you so much. And before I hand it off to Ben, on behalf of Digital, would like to thank all of you, Craig, Celia, Lawrence, Patricia, for carving out time out of your schedules as well. As Craig mentioned, and as other panelists have said as well, I mean, it's been a very insightful for all of us on this side. And thank you for sharing your insights as folks look to try to demystify this and forge ahead in their commercialization venture. So Ben, I'll hand it off now to you. Thank you again, everyone.
Thanks so much, Jen. And again, thank you to our speakers for sharing their time and your expertise. As a reminder for all of our attendees, this discussion was recorded and it will be shared with all of you after the session. And with that, I hope you all will join us for our next conversation, and I hope you all have a great rest of your day. Thanks so much, everyone.